9 justices, 0 dissents. And a federal judge just got corrected in writing by every single member of the highest court in the United States. Not once, not twice, 3 times in the same ruling. This did not happen quietly. The Supreme Court did not issue a narrow procedural order and move on. They wrote, they explained, they named the specific legal errors, and they corrected every single one, unanimously, in a single emergency application. I have been tracking Supreme Court decisions for years. Emergency stay applications happen. Unanimous ones happen too. But the language in this ruling, the specific, pointed, almost personal rebuke of a federal judge, that is rare. That tells you the court was not just resolving a dispute, they were sending a message. And by the time this video is over, you are going to understand exactly what that message was, who it was for, and why it changes the legal landscape for redistricting challenges in every state in this country. Here is what we are covering today. First, exactly what the Supreme Court said, and why the language matters just as much as the outcome. Because when the court writes this aggressively on an emergency application, the words they choose are not accidental. Second, the 3 specific legal errors the lower court made. And I will warn you right now, error number 2 is going to change how redistricting challengers can even bring a case going forward. This one has national implications. Third, and this is the part almost everyone is missing, there are 4 words buried in this opinion about state sovereignty. 4 words that I guarantee will be cited in redistricting courtrooms for the next 20 years. I am going to tell you exactly what they are. Stay with me through all 3. What the Supreme Court put in writing here does not just affect one state's congressional districts. It sends a direct signal to every federal district court judge in this country. Let me show you exactly what that signal was. To understand how this confrontation reached the point of an emergency Supreme Court ruling, you need to know what the Supreme Court had already told federal courts to do. Not long ago, the Supreme Court issued a landmark decision that reshaped how federal courts must evaluate redistricting challenges under Section 2 of the Voting Rights Act. That ruling was explicit. It established a controlling framework, a legal standard that every federal court was now required to follow. Here is what that framework required. 1. Federal courts must separate race from partisan politics. A state's partisan decisions cannot be treated as automatic evidence of racial discrimination. 2. Courts must honor traditional redistricting principles, preserving communities of interest, respecting geographic and political boundaries, avoiding configurations that unnecessarily pair incumbents. 3. Courts must presume that state legislators acted in good faith when drawing their maps, unless there is specific, concrete evidence to overcome that presumption. The court was not subtle. This is the framework. Use it. Apply it faithfully. Do not substitute your own judgment for the standard we just established. Now, what do you think happened when this case came back before the district court? The lower court had exactly one job. Apply the new framework. Run the state's map through the test the Supreme Court just handed down. If the challengers cannot satisfy that test, the challenge fails. Instead, the district court blocked the state's map entirely, then replaced it with a map drawn by a court-appointed special master. Let that land for a moment. The map the state legislature drew, chosen by elected representatives of the people of that state, was set aside, and a federal court substituted its own map in its place, essentially telling the state legislature, "We think we can draw your congressional districts better than you can." The state immediately filed an emergency application directly to the Supreme Court, and what came back was unanimous, fast, and unprecedented in tone. Not just a stay, not a quiet order telling the lower court to reconsider. The Supreme Court wrote. They explained. They identified the specific errors, and they corrected every single one. There were 3 errors, and each one matters. Error number 1. The lower court inverted the presumption of good faith. Here's what that means in plain terms. When a state legislature draws an election map, the law presumes they acted in good faith. The presumption says these are elected legislators doing their constitutional job, and we start from that assumption, unless specific, concrete evidence proves otherwise. This is not a technicality. It is a structural protection built into how our courts evaluate state government action. It is foundational. The lower court took the state's decision to appeal prior court orders, a completely legal action, a constitutionally protected right, and used that appeal as evidence of discriminatory intent. Read that back slowly. The court argued, you disagreed with our prior rulings, you challenged them through proper legal channels, therefore you must be acting in bad faith. The Supreme Court's response was direct and it was pointed. A state's decision to appeal a ruling it believes is wrong is not evidence of bad faith. It is the exercise of a legal right. Using it as evidence of discriminatory intent, the court wrote, inverts the presumption entirely. Inverts. That is the Supreme Court telling this lower court, you had the legal standard exactly backwards. Not slightly off, backwards. The entire analysis started from an inverted foundation. Think about what that correction means going forward. Every federal court in the country now has this in writing. If you try to use a state's legal disagreement with prior orders as evidence against the state in a redistricting case, 9 justices have already told you, in a published opinion, that you have the standard exactly backwards. That is error 1. Before I get to error number 2, I want to ask you something. How many redistricting cases do you think are pending in federal courts right now across the country? Dozens. Multiple states. Different facts, different maps, different challengers, different judges. Every single judge handling one of those cases just read this opinion. Keep that in mind as I walk you through error number 2, because this one directly changes what challengers must prove to win a redistricting case anywhere in the country. Error number 2. The lower court misapplied the controlling standard for challenger maps. Under the framework the Supreme Court established, when challengers want to strike down a state's legislative map, they must do more than object to the existing map. They must propose an alternative. And that alternative must perform equally well across all legitimate redistricting objectives, not just the racial composition objective they are focused on. All of them, simultaneously. The challengers in this case proposed an alternative map, but their map failed to properly account for the state's valid interest in preserving historic communities of interest along the Gulf Coast. It also failed to account for the state's interest in avoiding configurations that unnecessarily pair sitting incumbents against each other. The lower court looked at those interests and made a judgment call. It treated them as secondary, less important than the racial equity concern being raised. The Supreme Court said, you cannot do that. A court's role in a redistricting challenge is not to weigh the state's redistricting interests against each other and pick a winner. The challenger must clear the bar on every legitimate criterion, not just demonstrate a different racial outcome. If your alternative map does better on racial composition, but worse on preserving communities of interest, the challenge fails. If your alternative does better on racial composition, but creates more incumbent pairings than the state's map, the challenge fails. The lower court did not apply that standard. It substituted its own weighing of priorities for the framework the Supreme Court established. And the Supreme Court corrected it, explicitly, in writing, for every future court to read and follow. For any legal team currently litigating one of those dozens of pending redistricting cases across the country, this is your new reality. Your proposed alternative map has to pass every test, not just the test you built your case around. That is error 2. Error number 3, and this is the one I told you about at the start, the one with the 4 words buried in it that will be cited for 20 years. But first, the Purcell Principle, because you need this foundation. The Purcell Principle is one of the most fundamental doctrines in election law. The rule? Federal courts should not be altering election procedures when an election is already underway. The reason is practical. Last-minute judicial changes to election maps cause real chaos, reassigning hundreds of thousands of voters, redrawing precinct boundaries, reprogramming voting systems, reprinting materials. That disruption harms democratic participation. It does not protect it. The lower court tried to argue around the Purcell Principle. It said, the special master map is already running. Keeping it in place is more convenient for election officials. Stability is better than disruption. The Supreme Court dismantled this in 2 moves. Move 1, convenience to election officials is not a legal basis for maintaining an unconstitutional court order. That framing is administrative preference dressed up as legal reasoning. It is not law. Move 2, and here are the 4 words. The court wrote this: sovereign states are completely free. completely free to decide whether adjusting their own election maps serves their residents' interests. Not partially free, not free within the supervision of federal courts, completely free. The court did not have to write that. They were already granting the stay. The stay was decided. They chose to add that language about state sovereignty anyway. That choice is deliberate. That is the court signaling where it is heading on a question much bigger than this single case. The bigger question is, how much authority do federal courts actually have to override what state legislatures decide about how their own elections are run? The answer the Supreme Court gave, in 4 words, is less than you think. Every state defending its legislative map against federal court interference is going to cite those 4 words. Every brief filed in every redistricting challenge for the next 20 years will include "sovereign states are completely free" as authority for why federal courts must clear a high bar before overriding a state's election decisions. That is error 3. And that is the 4 words. What happens next? So where does this case actually go from here? The state's legislative map is restored. The special master map is gone. Implementation for this election cycle is already underway. But the emergency stay is not the final legal word on this case. It is the end of the lower court's ability to interfere with this election. For the state to permanently protect its map, for future cycles, not just this one, it will need to file a petition asking the Supreme Court to take the full case on the merits. That petition is coming, and there is a very specific reason to believe the Supreme Court takes it and rules in the state's favor. Here is why. When the Supreme Court issues an emergency stay, one of the legal factors they must weigh is whether the requesting party has demonstrated a likelihood of success on the full merits of their case. If the party cannot show they are likely to win the underlying case, the stay does not issue. In this opinion, in the emergency stay ruling itself, the majority explicitly stated that the state had demonstrated a high likelihood of success on the merits of both its claims. I want you to understand what that language means in practice. In my years of tracking Supreme Court emergency jurisprudence, when the majority explicitly says a party has shown a high likelihood of success on the merits at the emergency stage, that party wins the full case. It is not a guarantee, but it is as close to a forecast as the court ever offers before actually ruling. The state is no longer playing defense. It is moving toward a final ruling that may lock in its map permanently and set national precedent restricting federal court redistricting overreach in every state going forward. Here is the part of this ruling that reaches far beyond one state's congressional districts. Dozens of redistricting cases are pending in federal courts right now. Different states, different maps, different challengers, different facts. But the same controlling framework, the same Supreme Court precedent, the same rules every federal court is now required to follow. Every single district court judge handling one of those cases just received a direct message from 9 justices. The message is not complicated. Apply the framework faithfully. Honor the presumptions we require. Apply the tests we defined. Do not substitute your own judgment for the standard we established. When the Supreme Court writes this aggressively in an emergency stay application, not a full merits opinion, an emergency application, they are not simply resolving a dispute between 2 parties. They are policing their own authority. They are drawing a line for every federal court in the country about what happens when a lower court decides it knows better than the Supreme Court. The line is clear. Follow our precedent. And if you do not, we will move fast, we will identify your specific errors by name, and 9 justices will attach their names to that correction in a published opinion. That message does not just affect redistricting cases. That message is about institutional authority. It is about who holds the final word on how federal law is applied. And the Supreme Court just reminded every court in this country that they do. Let me bring this to a close. What the Supreme Court established with this unanimous emergency ruling comes down to 4 things. State sovereignty over congressional election maps is a constitutional principle that federal courts must respect. And when they do not, the Supreme Court will move fast to correct them. The Purcell principle exists to protect elections from last-minute judicial chaos, and administrative convenience is not a valid reason to override it. The presumption of legislative good faith is not optional, and using a state's legal appeals as evidence of bad intent has the standard exactly backwards. And the controlling framework for how redistricting challenges are evaluated exists to be applied completely and faithfully, not selectively, not partially, and not with a lower court's policy preferences substituted for the test the Supreme Court defined. A lower court that ignores Supreme Court precedent because it disagrees with where that precedent leads is not interpreting the law. It is replacing the Supreme Court. 9 justices just told every federal court in this country they will not tolerate that when it comes to state election maps or anything else. That message carries the full weight of a unanimous court behind it. When the certiorari petition is filed and the Supreme Court moves to the next stage of this case, I will bring you the complete breakdown. This story is not over. If this kind of real-time constitutional analysis is what you are here for, Supreme Court rulings decoded, the legal language behind the headlines, what these decisions actually mean going forward, make sure you are subscribed and have notifications on, because what comes next in this case may be even bigger than what we covered today. I will see you in the next one.